In the two co-chairs of the conference here are two of the most eminent architects of the bankruptcy programs in existence in the United States. And I think Perry admitted during the course of the conference that we have in excess of $28 billion that's been made available to pay plaintiffs in the asbestos litigation. And there are, I think, 26 operating 23 operating bankruptcies now, and more coming. So there'll be more online, with $1 billion plus every year, flowing to these claimants,
ranging from $5 million in each trust to $3 billion.
And there are certain jurisdictions that have, as part of the case management order, they have provisions that relate to the trusts. Like in New York, Judge Heitler, I think there's a provision that requires a plaintiff who intends to file a proof of claim in a bankruptcy to file it within 10 days after the trial is designated, or within 90 days in an extremis case. There's also provisions in Washington that require, that provide that there'll be credits for the amounts that are actually paid by the trusts, and for amounts that would have been obtained had the plaintiffs diligently applied to the trusts for compensation. And the question I have for you, I'm interested to know, are there discussions in your courts with respect to the bankruptcy system that's in place that is now, after there was this huge wave of bankruptcy in the around 2000, 2001, now all these trusts are coming out online and all this money is flowing. Is there anything being done in your jurisdiction to try to take into account the money that's flowing in the bankruptcy system?
You hit the nail on the head, in my opinion, by saying there was a statute in Washington.
There's another case management order in Washington.
Okay. To me, whether or not to give credit to potential future settlement proceeds from a bankruptcy trust is inherently a matter left to the legislative branch of government. I am only authorized to give settlement credits for settlements received. I'm not authorized by law to give settlement credits for settlements that might be received once a claim has been made to the bankruptcy court. So that is inherently something that properly belongs to a branch of government other than my own.
Judge, I think it's important to echo a word that you said, might get paid. I don't know how many of your honors were here yesterday, but there was a pretty vibrant discussion about this. And first of all, the defendants have all the material necessary to evaluate whether or not a bankruptcy claim will get paid. They know, they've taken the plaintiff's deposition. They know every place he's worked. They know the different bankrupt companies' product ID at those places. So they can go to the trust distribution plan of any one of these bankruptcies, look up the scheduled value, and they can add up whatever they think that they're going to get. But the might is important because
Barry, this is your judicial panel.
No, it's important that they understand this, that there is exposure and medical criteria in each one of those trusts, and it's not a given that everyone's going to qualify for those payments.
Bankruptcy trust-related issue for all of you who are plaintiffs' lawyers. If you get a case on a referral from somebody else, don't go representing to the court and to the other side that no settlement, no monies have been paid from bankruptcy trusts when your referring lawyer did it before they sent the case to you and didn't bother to tell you about it. That has happened a number of times in front of me, and it mightily embarrassed the plaintiff lawyer who was making representations under oath and not under oath, but to me, which is worse. So, be very careful before you make those representations to a court or to the other side, because it makes you look real stupid.
Mr. O'Hara, the answer is no, and there probably should be discussions about how that would happen, because it's a complicated problem, but it's one. If a trial judge or a managing judge like me is going to understand the issue, we need to know all the pieces of the puzzle, not just exactly what's in front of us.
Go ahead.
Frankly, we have not had the issue come up. The lawyers on both sides of the asbestos case are very sophisticated. And if the case doesn't settle before trial, It's worked out, the numbers are worked out after trial. In terms of whatever the verdict is, the attorneys seem to, and all this happens probably ex cathedra without the involvement of the court. They work out, resolve the issues in terms of the settlement funds, and I have not seen it been presented to our court.
I don't think we give credit either, but I agree with Judge McBride, we probably should, and that's something to consider as I get my gears working.
Following up on the bankruptcy trust, and I am, by the way, a defense lawyer, has anyone made you aware that a federal judge in New York was told by plaintiffs' lawyers that he should disregard cross-claims that are deemed filed under your case management orders, and ultimately the judge denied our co-defendants standing to go into bankruptcy court on the grounds that case management orders and deemed cross-claims do not count, because in his view, they don't have a Rule 11 standard associated with it. And so, again, there are things happening in federal court that, as far as I know, are not being brought to your attention in terms of these bankruptcy trusts and what's happening and the effects your CMOs do and do not happen, or have, sorry.
The answer to your question is no, nobody's made me aware of that. I think, no.
The unawareness level here is very thorough. You know, we are not here to bluff you any more than normal. We manage what we try to manage, but little things like explaining to a judge that you know that there might be a problem settling this case because down the hall there is a 6 weeks coverage trial just about the asbestos claims that you're trying to settle. You know, little pieces of the puzzle don't necessarily all get floated in front of us. And we probably need a better newsletter on the topic, or, you know, how about Twitter?
A website.
You know, yeah.
Get a website.
It's Twitter now.
Judge Moss.
I'm behind.
Judge Moss, I want to follow up on your answer. When you were saying that you should look at that, are you talking about for bankruptcy claims that have been approved and money's been paid? There's been a settlement for that bankruptcy?
I mean, I think it's something we need to consider. And, you know, I don't make rules unless I talk with the lawyers, but that's something that I might bring up.
Oh, if the money's been paid, there's
Right.
absolutely an
Yeah.
entitlement to
Right.
credit. But what
I
if?
just wanted to clarify
What if
that.
the application's not been made, but could be made, probably will be made, and you can more or less estimate what the person might or might not receive?
But that's guesstimation.
Yeah, that's
Yes.
a coulda, woulda, shoulda.
That's
Well,
guesstimation.
It's up to the legislature whether or not, I think, it's up to our respective state legislatures whether we're mandated to give credit for prospective settlements.
Nobody's mandated anything, but the coulda, woulda, shouldas, that I don't know.